Good evening, or good morning, as the case may be, and thank you so much for joining us today. My name is Hirokazu Miyazaki, K. Davis Professor and Professor of Anthropology at Northwestern University. I also serve as specially appointed professor in the International Peace and Coexistence Program at Hiroshima University and a peace correspondent for the city of Nagasaki. First, I'd like to take a moment to remind everyone that you can listen to this event in either English or Japanese. Please go ahead and click the interpretation button at the bottom of your screen and select your language, English or Japanese, if you haven't already. We have also put instructions on how to do this in the chat box. I want to begin by thanking Northwestern University's Roberta Buffett Institute for Global Affairs and the Bulletin of the Atomic Scientists for their co-sponsorship of and many contributions to this event. I especially thank Rachel Bronson, President and CEO of the Bulletin, and Dana Dion, Director of Global Communications, Engagement and Outreach at the Buffett Institute, and also at the Northwestern University Office of Global Communications and Marketing, and her team, including Jude Appleby, Ahmed Khan, Dylan Peterson, and Hiroko Stolovic, for their guidance and encouragement at every step of the preparation for this event. I also thank our partners in Tokyo and Fukushima, including Keiko Nishizawa, Masayuki Otsuka, and Shimizu Suzuki for their kind assistance. I also want to express my deep gratitude to Ariel Schwartz, Tim McLellan, and especially Chris Diaz, digital publishing librarian at Northwestern University Libraries, for their creative work that is reflected in all dimensions of the report we are launching today. Finally, I'd like to acknowledge the many contributions of the Cornell University Mario Einaudi Center for International Studies and Cornell Law School, where this project originally began. This event marks the release of the new Nuclear Compensation Lessons from Fukushima report, which is an outgrowth of 5 years of collaboration among scholars and experts across 3 continents, many of whom are here with us today. The report examines nuclear disaster compensation schemes surrounding the 3 Mile Island, Chernobyl, and Fukushima nuclear disasters, highlights where they have fallen short, and calls for more intentional, inclusive dialogue between experts and citizens on nuclear power and its many consequences. Today, you will hear from several of the report's authors, as well as voices from Fukushima, including Kazuhiro Yoshida, mayor of the town of Namie in Fukushima, as well as victims of the Fukushima disaster, including Masakazu Suzuki and Hidenori Konno, who are leaders of the plaintiffs in lawsuits against the Japanese government and Tokyo Electric Power Company, TEPCO. We will then bring a panel of experts to the stage for discussion of a broad range of nuclear energy and disaster preparedness issues, including Bulletin of the Atomic Scientists President and CEO Rachel Bronson, University of Chicago Professor Robert Wozner, the Argonne National Laboratory's Edward Tansman, and former U.S. Nuclear Regulatory Commission Chairman Alison McFarlane. You will have the opportunity to participate in a Q&A session that includes all of today's speakers at the end of the program. In the meantime, I encourage you to submit any questions that come to mind throughout the program via the chat box at the bottom of your Zoom screen. Please be sure to note the name of the speaker to whom you would like to direct your question, or simply post your question if it is a general one intended for any speaker who wishes to answer. I would now like to introduce one of the co-authors of the report, Annalise Wiles, who is Executive Director of the Northwestern Roberta Buffett Institute for Global Affairs and Associate Provost for Global Affairs at Northwestern University. Annalise is also the founder of the Meridian 180 community behind the report we are releasing today. Annalise, over to you.
Thank you very much, Hiro. And hello, everyone. We're so grateful for your participation in today's event. And I want to echo Hiro's words of thanks to the many individuals and organizations that contributed to making it possible. In particular, I want to thank Roberta Buffett Elliott for joining us today and for making all of our work at Northwestern Buffett possible. The roots of the Nuclear Disaster Compensation Lessons from Fukushima report we're releasing today stem in part from the personal experiences that many of us had of the Great East Japan earthquake and Fukushima nuclear disaster of 2011. And when the dust settled in Japan, the consensus was that the nuclear disaster could have at least been mitigated and perhaps avoided if academics, policymakers, engineers, and representatives of government and civil society had been talking more to each other. And those events brought home the fact that the silos we build around our work can quite literally kill. The grim and humbling realization of this inspired us to launch the Meridian 180 community that Hiro mentioned. And Meridian 180 invites leaders and creative thinkers from around the world to exchange ideas and develop adaptive solutions to economic, environmental, and political issues. Meridian 180 is designed to break down barriers to new thinking, whether those barriers are disciplinary or language barriers or national boundaries or barriers of different political points of view, in order to prepare for the next great crisis. And of course, that is the goal of this report. Meridian 180's members are scholars, lawyers, policymakers, activists, and business professionals who cross the divide between the academy, the industry, and the public sector. And since 2011, Meridian 180 has hosted more than 55 virtual conferences in which members engage in a frank and open discussion, translated into English, Chinese, Japanese, Korean, and now Italian and Arabic, to foster a truly global conversation. Now, it's my pleasure and honor to introduce you today to our keynote speaker, Alison McFarlane. Alison is the director of the School of Public Policy and Global Affairs at the University of British Columbia and former chairman of the United States Nuclear Regulatory Commission. As chairman, Alison was responsible for the safety of all US commercial nuclear reactors, for the regulation of medical radiation and nuclear waste in the United States, and for representing the US in negotiations with international nuclear regulators. During her tenure, she pushed for a more open dialogue with the public, for greater engagement with international nuclear regulators, and following the Fukushima event, for stricter safety protocols at US nuclear reactors. Alison is also the former director of the Institute for International Science and Technology at George Washington University and was the 2018 Fulbright Distinguished Chair in Applied Public Policy at Flinders University and Carnegie Mellon Adelaide. She also has been a faculty member at Georgia Tech and George Mason University and has held fellowships at Radcliffe, MIT, Stanford, and Harvard, and the Woodrow Wilson Center. Alison also served on the Blue Ribbon Commission on America's Nuclear Future, which was created by the Obama administration to develop a national strategy for high-level nuclear waste. And she serves on the National Academy of Sciences panel and has chaired the Science and Security Board of the Bulletin of the Atomic Scientists. Alison's research focuses on environmental policy and international security issues associated with nuclear energy, including nuclear waste disposal, nuclear regulation, and science and technology policy. So it's a great pleasure to have you here, Alison. Welcome, and thank you for joining us. Over to you.
Thank you so much, Annalise. That was a very kind introduction. And thank you so much for inviting me here to speak with you today. I'm very honored to do so. I'm going to share some slides with you. And let's see. Get them going. Now, can you all see them? Or do you see everything?
We see them.
You see them?
We see your notes too, Alison.
Yeah,
That's okay.
Let's see if this changes things. No, is that better?
Perfect.
But do you see my chat and everything?
Nope, just right.
Good. Excellent. Okay. All right. So I'm going to talk about the accident at Fukushima and talk about some of the lessons we should have learned and implications for the future of nuclear energy. And I'm going to try not to take up too much time in doing so. But before I get to those lessons and implications, I just want to remind us about the accident, which I'm sure for many of you this is territory you've already covered, but in any case, 10 years ago, on March 11th, there was a magnitude 9.0 earthquake, as Annalise mentioned, the Great East Japan earthquake, that shook the entire region. Within 50 minutes of that earthquake, a massive tsunami hit that east coast of Japan, and in particular hit the Fukushima Daiichi nuclear power plant with a wall of water around 15 meters high. This water immediately affected the reactors there. There were 6 reactors at Fukushima Daiichi. 5 were in operation, sorry. And at the time, and you can see based on this image that 20 to 40 feet of water immediately drowned the facility. Now, the facility had already lost off-site electricity because of the earthquake. This tsunami drowned all the backup systems, the diesel generators, the fuel for the diesel generators, and the batteries, which were all stored in the basements of these buildings. And that led to a situation known to bring a chill to the hearts of all nuclear engineers called station blackout. Within hours, the unit 1 reactor melted, the core melted, and we then had hydrogen explosions, and the cores of units 2 and 3 also melted in the following days, with more damage to the site and releases of radiation and significant contamination of areas to the northwest of the facility, which to this day remain difficult to return zones. This was actually in some ways a best case situation because most of the radiation was blown off to sea during the accident. And of course, this resulted in abandoned villages and communities in the area. And as cleanup proceeded, amassed, instead of rice fields, we see fields of nuclear waste in the area. And at the site itself, massive tanks of water that has been partially cleaned up. And so that's the situation at Fukushima. I was able to visit the facility twice, once in December 2012 and again in 2015. In the 2012 visit, we were able to actually go onto and into the Unit 4 building and look at on the roof where the spent fuel pool was, and then into the building. And you can see that this was required us to suit up completely to protect ourselves. So I do have some firsthand experience with the area, and I'm happy to talk more about that. But let's talk about the lessons that I have taken away from this accident, and so what we should have learned and what this means for the future of nuclear energy. And the first lesson, I think, relates directly to the topic of this conference. And that is, reactor accidents aren't measured by deaths. And unfortunately, we see people in the media and people in industry and in experts in nuclear energy continuing to make this error. And I think that Hiro and Annalise, that you guys and your group here have done a real service to the larger global community to bring up the issue of compensation and focus us all on the issues associated with the realities of dealing with a nuclear reactor accident. Because clearly, before the Fukushima accident, countries that operate nuclear energy did not pay enough attention to this, and I think they still have not. So I really applaud you for your efforts here. I just want to highlight for you a couple things that you can read all the time, basically. In Forbes magazine in 2019, Michael Schellenberger wrote, quote, "The radiation from Fukushima and the 3 Mile Island will kill 0 people. In other words, the main lesson that should be drawn from the worst nuclear accidents is that nuclear energy has always been inherently safe." And just a few days ago in the Globe and Mail, Doug Saunders wrote, I quote, "Amid all the tsunami and evacuation deaths, the reactor itself proved to be close to harmless." I'm sure there are many people who would vehemently disagree with these statements. I think that really one of the main lessons from Fukushima is that dead people isn't the relevant unit of measure. There was so much loss of land, loss of community, loss of jobs, loss of industries, loss of family. The 160,000 people evacuated, fewer than 35% returned to the area. The economic costs, besides those costs, which are difficult to measure, the economic costs have been enormous. For decontamination, decommissioning, and compensation alone, cost estimates are between US $188 billion up to US $740 billion. And this does not include costs for electricity market impacts. And you can see the figure on the right shows that after 2011, the percentage of nuclear power in the electricity production in Japan fell to 0. Before 2011, it was about 30%. And largely this loss of electricity was made up by fossil fuels. There have also been upgrades to existing plants based on the learnings from the Fukushima Daiichi accident. 24 of the original 54 reactors have been permanently shut down in Japan, and so that loss has to be calculated as well, and only 9 are operating now. So the overall lesson is that the economic and societal impacts of accidents must be considered when plants are being licensed. And as much done as possible to prevent these accidents should be done. Second lesson is there should be periodic reviews of natural hazards that face these plants. And this was a lesson certainly that came out of Fukushima. The massive earthquake and the massive tsunami actually were potentially predictable, but only fairly recently in the science. Maybe about 10 years or so before the accident happened, did the science sort of catch up to this? And I'm happy to talk about that more in the Q&A. So many countries drew the lesson that you need to periodically review seismic hazards, flooding hazards, especially in the face of climate change, other hazards like potential for projectiles from tornadoes, hurricane force winds, fire, etc. And the US actually went down this path. Many US plants were cited and licensed based on an analysis of seismic and flooding, other natural hazards that's more than 40 years old. In terms of the seismic hazards, geology has significantly changed in that time. The US Nuclear Regulatory Commission was actually requiring seismic and flooding hazard updates, and until 2019, when they abandoned this effort, when the 3 Republican members of the commission decided to stop this effort. But I think really the larger lesson is that natural hazards have to be reevaluated at regular intervals, and updated knowledge has to be used to improve safety. The third lesson is that we really need to manage the entire fuel cycle, especially what those of us call the back end of the fuel cycle, or dealing with the nuclear waste. And a lack of planning for the nuclear waste can have big implications for accidents in the future. And we learned this up close and personal with the situation with Unit 4's pool. So in the diagram to the right is a schematic of the reactor in Unit 4. Can you see my arrow here? Hopefully you can. In the middle is the reactor vessel, and the pool is beside it. And the picture that I showed you for the top of the facility, that's here. This roof bit was blown off. So Unit 4 had just discharged all the fuel from the core of the reactor into the pool to do maintenance on the reactor. And so you had very hot fuel in that pool. Now that pool already had quite a bit of spent fuel in it. And so when the accident happened, there was no more active circulation of water. There were no more pumps to run the water. And there was a potential that the water in the pool would get very hot and it would start to boil off. If that happened and the fuel was uncovered, then there was a potential for massive radiation release. By Japanese analysis, if this had happened, the radiation could have spread all the way to Tokyo in significant amounts. So this was a disaster that they were really, really worried about. And in fact, they were within some days of uncovering the spent fuel when they finally were able to get water into that pool. So why was this an issue? Because the Fukushima Daiichi site actually had a centralized pool in addition to the pools at the individual reactors, and it also had dry cask storage for the spent fuel. So the real problem is that Japan did not have an operating plan for dealing with the spent fuel in a final way. And in fact, no country does. No country has a final plan for their spent nuclear fuel that is working right now. Finland is perhaps the closest because it is in the process of constructing a repository, deep mine geologic repository for its spent fuel, but everybody else is further away. So really, we need a plan to deal with the nuclear waste. Japan's plan was to bring the spent nuclear fuel to the Rakasho reprocessing facility and reprocess it, and then do something with the high-level waste, probably put it in a deep geologic repository, but they're pretty far from finding one of those. But the Rakasho plant isn't operating either yet. And so I think the overall lesson here is that you can't operate nuclear energy responsibly without having a clear and decisive plan for dealing with the nuclear waste, and not just the spent nuclear fuel, but all levels of nuclear waste. So turning to the fourth lesson, and that is that sometimes there are actually some straightforward solutions to some of these potential safety issues. And this became clear with the contamination that resulted from the accident at Fukushima and from Chernobyl. So it turns out that to prevent contamination, one can do so fairly straightforwardly by adding a filter to a containment venting system. Now let me go back and say something about the containment venting system. So in the image there, you see the reactor vessel, and around it is a sort of hourglass shaped additional vessel, and that's called the containment. It's actually has walls that are about 3 feet thick, steel reinforced concrete. And why do you need that? Well, Chernobyl did not have one of those, and when the reactor melted down, the radiation was immediately released into the environment. The containment is designed to contain the radiation, and that works. But the problem with the containments at Fukushima is that they're very small, so it was easy for them to become overpressured. When they became overpressured, if you can't open the vent, you will end up exploding cracking the containment and then releasing radiation. And that happened at Fukushima. Now, if you add a vent that you can, under accident conditions, operate, and you add a pipe that takes the gases from that containment and runs them through a tank of water, the water will strip off most of the radiation. And therefore, you won't really have too much contamination to contend with. Many countries actually began to learn this lesson initially after 3 Mile Island, and certainly after Chernobyl. Many European countries had added these filters to their venting systems for their reactors. And you can see the list of countries that have decided to add or have already added these filters. And you can see the shorter list of countries that have not, including the United States. After the Fukushima accident, the United States Nuclear Regulatory Commission considered adding these filters. The staff at the agency believed that they should be added, but again, the commission decided not to add them. So again, this lesson is the lesson of taking advantage of straightforward solutions to some safety issues. And then the final lesson, which is one of the most important lessons, I think, has to do with the importance of an independent regulator. After the Fukushima accident, there were a couple of very good analyses done in Japan of the accident itself. One was the one pictured here by the Diet of Japan, which said that one of the main problems or root causes of the accident was the lack of independence of the regulator and the collusion that occurred between the regulator, the industry, and the government. It's very important to have an independent regulator. That would be a regulator that is not subject to political or industry influence. But you need more than that. You need your regulator to be well-resourced, both financially and in terms of human resources. You need adequate expertise. You need the central government to back the idea of the regulator. And the regulator has to have the ability to shut down facilities that it deems unsafe. And I think we've seen now what can happen when the regulator is not completely independent, that a country is at great risks in terms of both public health and in terms of its economy if it doesn't have adequate oversight of nuclear facilities. So let me then conclude with this image taken from the Diablo Canyon nuclear power plant in the United States. And it's an image of a tanker truck with a flammable material inside. And you probably can't see it very well, but there's a little, there's writing on the side of the truck here that says 0 defect delivery. And it's difficult to read because the tanker truck is dented. And the lesson here is that just because you say it's so doesn't make it so. You really need to follow through on all of these lessons to make sure that that they're reality, and you need oversight on all of this. It's essential for the safe operation of nuclear power. So I will end there. Thank you very much.
Thank you so very much, Alison, for your insightful remarks. And it is real honor to have you here with us today. Over the course of the next 30 minutes, we will hear from several of the nuclear compensation lessons from Fukushima report co-authors, including Yuki Ashina, who is a partner at the Hinodecho Law Office in Shizuoka, Japan, Mary Mitchell, assistant professor at the University of Toronto's Center for Criminology and Socio-Legal Studies, Annalise Wiles, executive director of the Roberta Buffett Institute for Global Affairs, associate provost for Global Affairs, and professor of law at Northwestern University, Sonia Schmidt, associate professor of science, technology, and society at Virginia Tech, and Dai Yokomizo, professor in the Graduate School of Law at Nagoya University. As you listen to their presentations and insights, please submit any questions you have for them through the Zoom chat box at the bottom of your screen. And please note if the question is for a particular speaker or for the entire group. We will address as many questions as possible during the live Q&A session at the end of today's program. Thank you very much, and I will now let you hear from the authors.
Hello, everyone. I'm Yuki Ashina, attorney at law, one of members in Fukushima report team. It is my great honor to have such a precious opportunity to tell you what happened in Fukushima accident from the viewpoint of compensation. Our team has 4 authors, Takao Suwami, Satsuki Takahashi, Nobuya Fujinaga, and me. As we have engaged in different activities regarding Fukushima accident, I believe our collaborative work is really unique and interesting. Today, I'd like to explain the content of our report in a few minutes. Our report is roughly divided 3 parts. First part is an introduction of Japanese damage compensation scheme for Fukushima accident. Second part is the uniquest part, case study reports of nuclear damage. We picked 4 types of victims: mandatory evacuees, voluntary evacuees, farmers, and fishing industry. Third part is focusing the limitation of compensation. We tackled with not only the flaws of present Japanese compensation scheme, but also the effectivity of compensation itself as a remedy to reconstruct victims' lives. We set 5 questions in this part. Each question has each difficulty to answer, but I believe each difficulty we faced is crucial to understand what a severe nuclear accident is like. Thus, we tried to find answers as much as possible. Today, as the time is limited, I focus on explaining 2 of them, number 2 and number 5. As for number 2, what counts as damage? We found that nuclear damage belongs not only to specific individuals, but also to a region covering the entire area. I want you to know, as a result of nuclear accident, the affected areas were completely and fundamentally destroyed. Victims who were forced to evacuate not only lost their assets and means of living, but also the local community which had served as an essential part of their daily lives. However, the present current tort law system, just developed with a focus on individuals, cannot cover the destruction of entire regions, and this much causes the current system to be dysfunctional, we believe. And let's see the final question, number 5. What is considered as a disaster reconstruction? In our understanding, the purpose of victims' relief is to recover the serious damages stemmed from the accident and to rebuild their lives and to regain the peaceful daily lives they had before the accident. However, for the victims of the Fukushima accident, the compensation may be useful to some extent for their day-to-day living. But obviously, it's not enough to overcome the obstacles to reconstruct their new lives. We are forced to face the fundamental question, how much we should rely on the compensation system to achieve reconstruction from the disaster. It's not easy to solve this issue. We may need creative ideas for rebuilding victims' lives from all over the world, including you. Finally, 10 years have already passed since Fukushima accident happened. But what we want to emphasize most is it's not the past one. It's ongoing. It is one of the examples. The extension of the statute of limitation became the hot issue among the attorneys who have engaged in supportive activities for victims. We all know what victims wish best is to retrieve the original lives they had before the accident. However, it is a clear fact that unfortunately, we have not succeeded in meeting their wishes for as long as 10 years. It is our hope that our report can contribute to provide insightful thoughts on how we should deal with severe nuclear accidents, both ongoing and those probably occurring somewhere in the world. Thank you.
My name is Mary Mitchell, and I'm an assistant professor at the University of Toronto. I'll be offering a few insights today on the United States' liability and compensation regime for civilian nuclear power production. My comments are refracted through the prism of the 1979 meltdown at 3 Mile Island. Now, this was the first major incident at a civilian nuclear power plant worldwide, and it was the first major test of the US liability and compensation regime known as the Price-Anderson Nuclear Industries Indemnity Act of 1957. That act had been designed during the Cold War to promote the participation of private corporations and insurers by limiting the liability that industry participants would bear in the event that a meltdown caused harm to the public. It set up a hybrid public-private system in which compensation claims would be handled by private insurers and could subsequently be litigated in the US courts. Now, in the event that claims were to outstrip the limited funds, either the government would need to step in or injuries might go uncompensated. Now, as most viewers today are probably aware, the 3 Mile Island incident, though significant, caused far less offsite damage than Fukushima or Chernobyl. Perhaps counterintuitively, I think this actually makes 3 Mile Island an important event for examining nuclear liability and compensation. Precisely because its offsite effects were less pronounced, 3 Mile Island really highlights the tensions over how the boundaries of a disaster are drawn in time, in space, and with reference to communities that fear they might have been exposed. So 3 Mile Island has a few lessons to teach about liability and compensation. First, it draws attention to how nuclear compensation is almost always a problem of knowledge. After 3 Mile Island, estimates of offsite exposure were conducted by experts drawn from industry and government agencies. Now, these studies were extensive and they suggested that there had only been a very low level of offsite exposure. At the same time, however, these studies did not address community concerns about health and environment. This brings me to my second and related point. is that 3 Mile Island showcased the pervasive problems of trust in the nuclear field and how liability and compensation are questions in part of trust. Because experts did not engage with community concerns, some members of the public after 3 Mile Island began to believe that there had been a cover-up. Now, looking at these claims in historical perspective, I think it's important to note that members of the public were asked to place their trust in corporations and government agencies in the nuclear field at the very same time that cover-ups and secrecy over the public harm of the US nuclear weapons program were coming to light. So the long duration of controversy after 3 Mile Island, extending for several decades, even after scientific consensus that very little offset exposure had been present, I think shows the lasting impacts of broken public trust in the nuclear field generally. So if governments wish to continue to promote or subsidize nuclear power, that public trust needs to be re-engaged and I think reestablished. 3 Mile Island suggests that one way this could happen might be by enrolling affected and at-risk communities more fully in regulatory processes and elevating their concerns and their experiences to a place of heightened importance. Now, I also want to highlight in relation to these questions of trust and knowledge that the people who pressed their claims for decades after 3 Mile Island were mainly very sick members of the community. So these were individuals who were suffering and in some cases even dying from serious medical problems, mainly cancers. So that suffering, whatever its cause is, it's legitimate and it's real. People's questions then about the effects of 3 Mile Island, I think, were actually quite reasonable. They knew that the risk of certain cancers may be increased by exposure to ionizing radiation. And in fact, they were suffering from some of those cancers. So they wanted the inference that 3 Mile Island might have been related to their illnesses to be investigated more thoroughly. They wanted more monitoring of health in the community. Now, this isn't irrational, and I think we should expect and embrace that people located near nuclear power plants or even near other heavy industries are going to desire monitoring and investigations about their health and about connections between accidents and illnesses. So bringing these issues of knowledge and trust together, after 3 Mile Island, community members essentially argued for a new scientific social compact. They argued that their exposure to an unequal proportion of the risk from a meltdown entitled their concerns and their questions to extended scientific attention. They argued essentially that the incident was a source of environmental injustice because it had entailed epistemic injustice, because their concerns hadn't been addressed. They hadn't been involved in making questions or answering questions. So to remedy this, they wanted government regulators and scientists to focus more assiduously on the health of their bodies, on the health of their communities, on the health of their environments. In other words, they argued that if some people are going to bear more of the risk than others, those people's concerns, their questions, their health, their experiences needed to be made more central within regulatory regimes, and especially in crafting scientific questions and guiding extended scientific studies. So to conclude, the US regime of limited liability was at its genesis predicated on Cold War goals of promoting nuclear power and protecting private industry participation. In 2021, amidst renewed calls for investments in nuclear power, but also in the wake of 3 major incidents, it is time to place the protection and the experiences of at-risk and harmed communities more toward the center of regulatory regimes and processes in the US and beyond.
Hi, my name is Sonia Schmid. I'm an associate professor in the Department of Science, Technology, and Society at Virginia Tech, and I'll be talking about nuclear liability and compensation models after Chernobyl. So up front, just a reminder, our guiding questions were: who is a victim, what counts as damage, and who's responsible for the compensation? I want to make a few other points about the specific Chernobyl case. Chernobyl is a Soviet, but also a post-Soviet case. So I'm not only going to look at what happened during the Soviet Union times, which ended in 1991, but also focus on the successor states, Ukraine, Russia, and Belarus, who were most affected by the fallout from Chernobyl. Another important thing to keep in mind is that Soviet and also post-Soviet citizens rarely went to court. That's an important cultural distinction. And finally, just a note on my sources. So I looked at laws, I looked at treaties and agreements, I looked at law journals, and I also talked to some Ukrainian regulators involved with the Chernobyl law. So at the time of the accident on April 26, 1986, there was no legal basis on which affected individuals could demand legal settlement from the government. It was 12 days after the accident, on May 7th, 1986, that the Soviet government issued a decree on terms of payment and material provisions for those working in the Chernobyl nuclear power plant zone. By 1990, 3 independent programs were put in place in Ukraine, Belarus, and a single region, Bryansk, in Russia. These programs focused first on the decontamination of territories and second on social protection. The amounts of compensations were based on different principles. In Russia, it was linked to the minimum wage. In Ukraine, it was based on a person's base salary. And in Belarus, it was a monthly premium based on a specific indexation. Only in 1991, 5 years after the disaster, the Soviet Union adopted the following laws. There was a law of the Belarusian SSR, a law of the Ukrainian SSR, a law of the Russian FSSR, and a federal law on the social protection of citizens who suffered as a consequence of the Chernobyl catastrophes. All the other, the Belarusian, the Ukrainian, the Russian laws had similar titles to this federal law and concerned the protection of citizens who had been affected by Chernobyl. Almost immediately, the nuclear compensation framework faced a public debate that challenged how these laws applied to others affected by nuclear fallout. In particular, the population near the nuclear test site at Semipalatinsk in Kazakhstan, where the Soviet Union had conducted a large number of above ground and below ground nuclear weapons tests. And also, the challenges were whether those living in the area of Chelyabinsk in the Russian Urals would qualify for compensation under this law. Chelyabinsk is an area that was home to numerous facilities devoted to the most toxic parts of the nuclear fuel cycle, such as reprocessing and storage, and also had a history of severe radioactive contamination over the course of its history and operation. The situation was complicated by the grave economic crisis that shook the entire Soviet Union in the late 1980s and early 1990s, and the disintegration of the region's political system. The fall of the Berlin Wall in 1989, the end of the Warsaw Pact, and the eventual collapse of the Soviet Union in 1991 and 92 itself. So all of this led to compensation payments where they existed to be delayed, irregular, or partial. Worse yet, since most compensation came in the form of social benefits or privileges, such as access to a state-controlled system of housing, medical care, education, and transportation, with the changes in the system of governance, these benefits were either no longer available or lost their value altogether. There were also problems with the legislation relating to the underlying scientific knowledge. A territorial or aerial approach dominated the early Chernobyl legislation, but this was hampered by the highly variable classification of Chernobyl fallout in the affected areas. I go into much more detail on this in the chapter. And once the territorial approach was complemented by a dose approach, it faced similar challenges, as it was difficult, if not impossible, to determine the affected population's dose in the absence of continued, comprehensive, and reliable monitoring. Such monitoring was almost impossible given the lack of infrastructure and personnel, and also due to the difficulty of tracking the transient population of those subject to evacuation, as well as voluntary resettlement. The law then relied on imperfect underlying dose estimates, and also neglected complicating factors such as the fact that radiation risk to the population may vary greatly depending on location, duration of stay, and occupation, Also, calculating averages misses the wide variation in exposure. As I already mentioned, there was always insufficient dosimetric and epidemiological data. And then finally, humans vary in their sensitivity to radiation. So the law didn't take that into account either. So in closing, what the Soviet, post-Soviet example illustrates exceptionally well is that an adequate legal compensation scheme is always tied to a specific system of governance. And if that system changes, the existing compensation scheme may become irrelevant. Thank you.
I want to offer just a few thoughts today on the international legal regimes governing transboundary harm from nuclear reactor meltdowns. So what happens when a reactor melts down in one state and causes harm to people in another state? Now, there are three distinct regimes that cover this situation: the Vienna Convention, the Paris Convention, and the Convention on Supplementary Compensation. The Vienna and Paris Conventions, moreover, have several amendments and supplements. So depending on how one counts, there are 12 distinct international legal instruments that purport to govern transboundary harm from reactor meltdowns. Now, these instruments all govern reactor liability under private international law. This means that reactor liability is not conceived of as an issue for which states might be liable to one another. Now, I want to sketch out a couple of principles of liability that these regimes share in common before turning to some problems that they create. So first, these regimes channel liability strictly and exclusively to nuclear operators. That is, the nuclear plant operator, often a utility, is solely responsible for the harm. Manufacturers, suppliers, designers are excused from liability. Second, that operator must carry financial protection to cover its liability. However, third, an operator's liability is limited in time and it's limited in amount. Fourth and finally, disputes and claims are to be governed exclusively by the courts of the state where the installation was located and where the harm occurred. I want to highlight now very briefly some of the problem areas caused by these regimes. So first, there are just too many distinct international legal instruments, 12 in total, which creates a confusing and sometimes conflicting patchwork of coverages. Many of the major nuclear power states, moreover, haven't signed on to any regime. What protections a person will have, what claims they might be able to file, depends on the state in which they were located when they were harmed, the state where the reactor was located, and the regimes to which these two respective states may have acceded. So second, the levels of compensation are very low compared to the full cost of a nuclear catastrophe. And they assume that victims are only eligible to recover for very narrow kinds of damage claims for damage to body and to property. Third, and I think most important, the conventions don't specify a claims process, and they assume that the installation state, the state that generated the harm, will treat claimants from foreign jurisdictions fairly. So the burden is on regular people who have been harmed to file claims in foreign jurisdictions that have an interest in protecting their own industries and protecting their own public funds. And
Mary just described the patchwork of treaties governing transboundary claims, and she suggested that a significant portion of nuclear activity falls outside these treaties. So what avenues of compensation are available to victims when a treaty does not apply? This is the next question we address in our paper. And in the absence of a treaty, national laws of any country that is relevant to the dispute might apply. And by national laws of any country, we mean that there's a variety of countries that might entertain a lawsuit from victims, ranging from the place of the accident to the place of the residency of the victims to the place of business of the producer of the nuclear technology. And since the specific laws that govern nuclear accidents usually are made with local accidents in mind, in these transnational cases, ordinary common law or civil law principles often step in to fill the gap. And so one of the issues we trace in our paper is how legal doctrines that are not at all specific to nuclear accidents, things like jurisdiction or conflict of laws or tort law, will often determine whether injured people in nuclear accidents can get compensated or not. And this is confusing. It's really a patchwork of legal regimes. But we argue that it also can sometimes create some unexpected compensation possibilities for victims. So national laws regulating nuclear compensation are usually made with the assumption that a nuclear accident will be local. But in fact, nuclear accidents are almost always transboundary. And this is interesting to us because it creates certain opportunities for victims. The treaties that Mary described are largely made by governments working mainly with the nuclear industry and with relatively little input from victims groups. And the lacuna in these treaties means that victims get to frame the issues as they see them in local lawsuits, which can be exciting. So there are 3 cases that have come out of Fukushima that we discuss in the paper. And 2 of them involve people moving transboundary. And those 2 cases involve actually US Navy personnel who got sick after providing humanitarian relief at Fukushima, and they sued both TEPCO and GE in the United States. And one of the cases is actually the reverse. It's about the transboundary movement of technology, equipment, expertise, and capital. And in that case, Fukushima citizens came to Massachusetts to sue GE, the maker of the Fukushima Daiichi nuclear power plant, at its headquarters in Massachusetts. And all 3 of these cases turn on very technical legal doctrines that I don't have time to discuss today. And in all 3 cases, in the end, the victims were not successful in bringing their cases. All 3 cases got dismissed for quite technical reasons. But nevertheless, we argue that they leave open the very real possibility that next time, if the parties were different, or the country of the accident were different, or the manufacturer of the facility were different, that the case could come out differently. And so this raises some exciting possibilities, we think.
I'm Daio Komizo, Professor of Conflict of Laws at Nagoya University, Japan. What if plaintiffs chose to sue in Japan, seeking compensation for harm suffered outside of Japan? According to a leading expert in Japanese private international law, in that case, a Japanese court would hear the claim, but would apply foreign law to the extent that the claim could be maintained under Japanese law. The implication is that the claimant claim against the foreign manufacturer of the nuclear power plant could not proceed because a Japanese statute protects manufacturers of nuclear power plant from liability. These conflict of laws questions will be an important dimension of any future cross-border claims for compensation for nuclear accident in Asia. We can imagine, for example, an accident in a country in Asia leading to claim in Japan based on the pollution of the environment in Japan. As more states build more nuclear reactors, the risk of a transboundary incident grows. The existing imperfect system suffers from important defects in coverage. It also has substantial room for play in transboundary disputes. Victims have driven these novel litigations as a means of having a voice in questions of compensation. It seems that claimants' experiences in seeking compensation have remained less of a concern. We should continue to make our efforts to understand their experiences of diverse compensation systems, their understandings of the complicated legal situation, and their preferences for addressing nuclear risk moving forward.
Thank you very much, Yuki, Mary, Annalise, Sonia, and I for your important insights and critical contributions to our report. Next, we will hear from Fukushima citizens who will share their personal experiences in the aftermath of 2011 Great East Japan earthquake and nuclear accident. First, you will hear from Takao Suami, one of the authors of the report and a professor of law at Waseda University in Tokyo. Professor Suami and his colleagues at Waseda University set up a legal assistance program in Fukushima immediately following the disaster and have worked closely with several municipalities and groups of residents within the mandatory evacuation zone. As you listen to the remarks, once again, I would like to encourage those of you in attendance and an audience to submit any questions that come to mind through the Zoom chat box, and we will address as many of those questions as possible during the live Q&A portion of our program. Please be sure to specify if your question is for a specific speaker or if it is general question for the entire group. Thank you very much.
Thank you very much for joining us today. So I'm Takao Suami, professor of law at Waseda Law School. Just after the great earthquake hit northern part of Japan, a group of Waseda professors established a project to provide legal assistance to victims in Fukushima. Since March 2012, we have been working closely with several municipalities within the evacuation zone surrounding the Fukushima nuclear power station. The town of Namie is one of those municipalities. It is very much honored to introduce three speakers from Namie to all of you today. The first speaker is Mr. Kazuhiro Yoshida. He is the mayor of Namie. I worked closely with his predecessor, Mr. Tamotsu Baba. Mr. Baba negotiated hard with the central government and the TEPCO in order to protect the interests of the people of Namie. Unfortunately, Mr. Baba succumbed to cancer in 2018. Mr. Yoshida was elected as a mayor of Namie following Mr. Baba's untimely death and has taken over the challenging task. The second speaker is Mr. Masakazu Suzuki. In 2013, on behalf of more than 15,000 local residents, the town hall of Namie brought a complaint against the TEPCO before the Dispute Settlement Center for Nuclear Damage Compensation. They demanded an increase of compensation for mental anguish, but the TEPCO refused to amicably resolve the dispute. In 2018, therefore, hundreds of Namie people filed a lawsuit against the TEPCO in the Fukushima District Court. Mr. Suzuki is a leader of the plaintiffs in this collective lawsuit. And the third speaker is Mr. Hidenori Kono. Tsushima is a part of town of Namie, and the Tsushima area is still highly contaminated with a radioactive substance. No residents have been able to return to the area, and we don't know when they will be able to go home. In 2015, more than half of the former Tsushima residents brought a complaint against the TEPCO and the Japanese government in the Fukushima District Court. Their main claim focuses on the decontamination of land and houses in Tsushima. Mr. Kono is also a leader of the plaintiffs in this case. Damage caused by the nuclear accident is very serious and very complex too. The framework of damage compensations is only suitable to a small portion of the damage. I expect that their presentation will illuminate not widely known dimensions of nuclear damage. Thank you very much for your attention.
福島県浪井町長の吉田和弘でございます。今回は町の現状と賠償についてお伝えをいたします。あの日から10年、私どもは東日本大震災、そして原発事故から手を休めることなく復旧復興に進めてまいりました。一部の避難指示解除から4年が経ち、現在の居住人口は1600人弱、事故前の 8% も満たない状況ですが、事業や営農再開にご尽力をいただいている方々がたくさんおられます。また、新たな事業を展開する企業等もあり、町は今、町のこしから持続可能な町づくりに向けて全力で取り組んでおります。原発事故は生活のすべてを奪いました。土地や家、なりわいや仕事、そして知人や友人、家族までもがバラバラになりました。長い避難生活で心身の健康を害した町民もたくさんおられます。町は町民の生活再建のため、できる限りの賠償支援を進めてまいりましたが、10年経った今でも賠償の問題は解決しておりません。町内や避難先で生活再建された町民がいる一方で、生活が困窮している町民もおります。困窮の一つの原因として、賠償未請求があり、さまざまな事情により請求が困難で、いまだに賠償されていない町民は少数ですが、確かに存在をいたします。国は事故を再延長する法整備を進めず、東京電力は実質的に事故を運用しないと公表しておりますが、実態は不透明です。請求困難者は国にも東京電力にも放置された状況が続いております。精神的賠償の損害の賠償も問題の一つです。現在、全国各地で多数の訴訟が起きておりますが、確定判決には至っておらず、司法判断が分かれている状況であります。心の痛みは、経験がなければ理解が難しく、その痛みに対する賠償の評価は難しいだろうとは思います。しかしながら、例えば、地域コミュニティは、先祖代々から長い時間をかけて育ったものであって、解除後の町でも、避難先でもすぐに構築できるものではありません。原発事故によって失って初めて、地域での生活が見えない安心感に包まれ、心の拠り所であったことを痛感し、そして二度と戻ることはないと分かった時の苦しみは賠償されて当然であります。国と東京電力は原発事故により劇的に変わった町の姿から目を背けず、被害者の苦しみを真摯に受け止め、理解する努力が必要であります。その努力がなければ、賠償の問題は解決いたしません。本日はあいにく議会開催中のため、出席がかなわず、大変申し訳ありません。私どもの経験が未来に資するよう、このシンポジウムの成功をご記念申し上げ、メッセージとさせていただきます。ありがとうございました。
浪江原発訴訟原告団の鈴木正和でございます。浪江原発訴訟の経緯と私の思いについてお話しいたします。浪江原発訴訟は2018年11月27日、福島地方裁判所へ提訴。現在280世帯670名の原告団で、被告は国と東京電力です。提訴は集団 ADR の打ち切りが原因です。原子力損害賠償紛争審査会は、被害者を裁判をしないで早急に救済することを目的に ADR、和解仲介を設置しました。ADR はその運営で個別交渉とともに 集団交渉も定めています。町民の被災後の帰還意思は1年半の短期間に 64% から 17% へと激減。また、避難生活の重苦により、著しい経済的困窮に直面している実態が明らかになりました。浪江町長は、帰還意思の向上と経済的困窮から脱出することを目的に、自らが代表者になり、集団 ADR を決意し、2013年5月29日申し立て、最終的には 15,788 名、全町民の 75% 以上の規模になりました。10ヶ月後の2014年3月20日、仲介委員の和解案が提示。不満足ではあったが、受託を表明。しかし、東京電力は再三再四にわたる仲介委員の説得を無視し、約4年間に6回拒否し続けました。それが原因で2018年4月5日 ADR が打ち切られました。申し立てから打ち切りまでの5年間で失われた命は864名。打ち切りの3ヶ月後、代表の馬場保町長も無念の逝去。打ち切り後の対応は2200世帯が訴訟を希望。賠償金増額に加えて国と東京電力の責任と誤りを認めさせたい一心からでした。町の支援、弁護団の指導と助言のもと、4回の準備会を開催して、1、避難慰謝料の増額、2、コミュニティ破壊、3、被爆不安、4、期待権侵害の各慰謝料を請求内容にしました。集団 ADR 打ち切りは浪江町が最初で、その後すべての集団 ADR は打ち切られています。提訴したのは今のところ私どもだけです。現在6回の口頭弁論が開催され、7名の原告の意見陳述で原発事故被災の実相が赤裸々に述べられました。私は原告の一員として法廷内にとどまらず、国と東電の責任と事故原因及び核災の実相を多くの方々に周知したい。そして原発事故を自賠責保険の自動車事故以下に評価した中間指針の抜本的改定を国に迫りたいと思っています。今の私の思いを死に託しました。歩み方から目は遠く。資本の本性は自然の富を限りなく商品に変える利潤追求。その歴史は生産力による環境破壊の連続。結果は人間と自然の物質代謝を破綻。すべての原発は地球を総称する人間のおごり。人間は自然の小さな一つの命に過ぎず。自然の総称は人類の取り返しのつかない自滅へと誘う。世界中に釉薬する多種多様な新しい社会運動。環境と社会基盤が適正に保たれ、安全で公正な市民社会。自立した市民の新しい社会運動。歩み方から目は遠く。以上です。
私のふるさと浪江町津島地区は、東京都山手線の内側の約 1.5 倍の面積で9550ヘクタールあります。で、戸数約400戸、1400人ほどの中山間地区です。で、ふるさと津島には失ってみて初めて気づいたお金では測れない豊かさがありました。四季鮮やかな豊かな自然の中で先代から受け継いだ歴史、伝統、文化、伝承芸能、お墓などを大切に守って、住民同士の強い絆のもとに、年中行事を楽しみながら、互いに交流し、助け合って暮らす平穏な日常の生活です。地域社会の中で、日々平穏に生活することそのものがですね、私たちにとって生きがいであり、 楽しみ、喜びなんですね。また、その先人が永遠として築いてきた、そして私たちに託したものを受け継いで、さらに住みよい地域にして、それを将来世代につないでいく。そういうことも、そのためにですね、地区挙げて地域づくりとか活性化の事業に取り組むということ、そのものもですね、私たちにとっては大きな喜びだったんです。しかしですね、このような何気ない私たちにとっては大切な地域の生活が、原発事故による極めて高い放射能汚染のために突然断ち切られてしまいました。地域の人々は文字通り、県内外に離散し、親戚、友人との普段の交流もままならない状況にあります。何の罪とがもない私たちにとってこれほどの理不尽、不条理はありません。事故後すでに10年が経過しますが、高い放射線量に汚染されたふるさとは帰還困難区域とされて立ち入りが制限され、いつ戻れるのか、果たして帰ることができるのか、それさえもわからない避難生活を続けざるを得ない状況が続いています。この間、生きるために数多くの選択を迫られました、私たちは。しかし、自ら望んだ選択肢はただの一つもない、そういう過酷な生活です。加害者である国東電は私たちの人生を奪い、地域に住む人間としての誇り、尊厳ある存在を奪い去ったのです。ふるさとは唯一無二のかけがえのないものでありって代替できません。決して金銭には変えられず、賠償が支払われても満たしないものなのです。現在、帰還困難区域であるふるさと対馬は、わずかに地区の 1.6%、わずかに 1.6% です。に過ぎない、その一部分でですね、特定復興再生拠点区域の整備が進められて、除染や建物解体が進められています。しかし、そのいわゆる地区外、白地地区と普通に言いますけれども、そこにかかる今後の明確な方針は示されずに放置され続けています。無人状態で管理が行き届かない、ふるさとは荒廃が進んで、家や庭は荒れ放題となり、雑木が生い茂る田畑は林、森に変貌してしまいました。国は住宅などその生活に必要な部分は除染しますけれども、山林は除染しない方針です。しかし、私たちの地域は山林が8割を超えるので、その自然と一体の生活の対馬地区ですので、山林除染をしないということは、地域住民に帰るなというに等しいことなんですね。地区のわずかな一部のみを除染し、規制解除しても、地域の復興再生は望めません。10年を経過した現在でも、空間放射線量は依然として 0.5 から10マイクロシーベルトパーアワーなどの高い状況にあります。除染せずにこのまま放置されれば、私たちは廃村、帰民を強いられて、ふるさとを失ってしまう、そういう事態になりかねません。このありえない過酷な状況を引き起こした国及び東電の責任を問い、何としてもふるさとを取り戻したいと、半数に及ぶ地区住民が原告団を結成して裁判に臨んでいます。ふるさとを返してほしい。これは贅沢な望みなんでしょうか。私たちは決して金目、いわゆる賠償が目当てではありません。ふるさとが汚されたまま放置されずに以前の正常な環境を取り戻したい。ふるさとでの平穏な生活を取り戻したい。そのことだけが私たちの願いなのです。そして山林を含む地域一帯の豊かな自然の中で喜怒哀楽を共にする地域の人々との平穏な生活、その日常の暮らしの中で生涯を過ごし終えるのが望みなのです。
Thank you very much once again to Mayor Yoshida, Mr. Suzuki, and Mr. Kono for taking the time to share your perspectives and direct experiences with us today. I would now like to invite Annalise Wiles back to the stage to facilitate a panel discussion on the key insights and implications from the report in the next portion of the program.
Thank you very much, Hiro. And at this time, I would like to invite our panelists, Rachel Bronson, Allison McFarland, Robert Rosner, and Edward Tansman to turn their cameras on and microphones on and join me on the stage. And I'd like to remind all of you in our audience that you can listen to this portion of the event in Japanese as well as in English. There are instructions on how to do that in the chat box. Please also feel free to put questions in the Q&A. We will get to as many as we can in the question period. So with that, I'd like to formally introduce our panelists. Rachel Bronson is president and CEO of the Bulletin of the Atomic Scientists, which we are so grateful and proud to have as a co-sponsor for today's event. Welcome, Rachel. Allison, I don't see Allison. Allison McFarland should be joining us. Is director of the University of British Columbia School of Public Policy and Global Affairs and former chairman of the U.S. Nuclear Regulatory Commission. There she is. Great. Robert Rosner is the William E. Rather Distinguished Service Professor in the Harris School of Public Policy, Departments of Astronomy, Astrophysics, and Physics, and Enrico Fermi Institute and the College at the University of Chicago. And Edward Tansman is Manager of Emergency and Disaster Analytics at Argonne National Laboratory. Welcome to you all. So my first question is for all of you. We've just heard from some of those who found themselves in the path of the Fukushima nuclear disaster. We've also heard about the inadequacies of the system in place to compensate victims. I'd love to just hear your general reactions to what you've heard today, and in particular, if you could just signal what you consider to be the single most important lesson we should take from the major accident at Fukushima. I'd appreciate that. So let's start with you, Rachel.
Well, first of all, thank you for having me. We are most delighted to partner with Northwestern and the Buffett Center, and the heavy lifting is really for all of you, and we're just happy to be associated with this very important discussion. So thank you, Annalise, thank you, Hiro, and thank you to the organizers. What I think is the key takeaway from today's conversation is, if we're going to be serious about thinking through how we manage the two existential challenges of our time, climate change and nuclear risk and proliferation, we need to be very serious about how we manage possible solutions. And what I mean by that is that when we talk about climate change and we really take it on as a serious issue, we know we have to consider all sources of energy, and especially those that have a reduced carbon footprint. Nuclear energy becomes a possible solution. And yet we've heard, and it's not a silver bullet, nuclear power in the context of other sources of energy. But yet we've heard some of the consequences associated with nuclear power, which is a call to take that very, very seriously. Because if we cannot solve for some of the risk, and we cannot engage the public in a conversation about what will keep them safe and how they perceive themselves to be safe, it will be very difficult to move forward with really any source of energy, nuclear in particular. And so the reason that I bring up the two existential threats is because what we're seeing on the kind of nuclear risk side is a devolution of the international architecture around managing nuclear risk. And you cannot trade one existential threat for another. So we can't say that we're going to pursue nuclear power, civilian nuclear power, to manage climate change, and yet have collapsing verification regimes, a collapsing arms control regimes on the nuclear side. The two have to move in tandem. That is, if you're thinking about climate change and a space for nuclear power, you really have to be an arms controller or a nuclear arms abolitionist. The two really have to go together. But also, if there is a space for thinking about nuclear power, we have to manage the fact that civilians are being kept out of the conversation. The neighbors are kept out of the conversation, and we won't be able to move that forward. We could argue that what this shows is that there isn't a space for a future of nuclear power, and that is certainly one possibility. It will be very hard for us to achieve any sort of movement in the climate space unless we keep nuclear power in. So there's a much bigger conversation to be had, but this is absolutely linked to conversations around climate change, something unfortunately we have to take very seriously as we have these conversations.
Thank you. Robert, turn to you now.
Yeah, actually, I can't resist saying that I actually have two reactions. One of them has to do with the simple fact that what we heard from the residents was how the burden of powering modern society is borne really quite unequally by society's members. That you have folks that you might consider minor players, fishermen, plain old folks that live near the power plants that have nothing to do with the power plants. And they are the ones that are impacted most severely. And the schemes that we have for maintaining a social contract basically don't deal with this fundamental fact. The second has to do with something that's very much related to what Professor McFarland talked about at the beginning of this workshop. It's clear that the damage compensation schemes that exist, independent of which country we're really talking about, were never really designed to deal with the facts of very severe accidents. They were ad hoc and they're plainly unsatisfactory. The three accidents that we've seen, the severe accidents, are proof of that. And so what you're seeing here is really yet another issue of loss of trust by the nuclear regime that Allison talked about. It's just a driver of losing trust in energy technology that, as Rachel Bronson pointed out, may well be key to really dealing with climate change. So it's not very good news, I must say, and it's just sad, quite frankly.
Thanks for that. Edward?
I think that the statements that we heard from the residents who have lost their homes and lost their communities, those statements are genuine and very powerful. And I believe that in order to be prepared completely for the consequences associated with any energy form, nuclear or otherwise, any kind of energy production, it is imperative that the host communities, to give them a label, the places like Namiya, have to be part of a social contract that is entered into by them, that willingly and a social contract that is respected in all manners by all parties, come what may. The additional energy, the additional burden that people bear has to be recognized in advance, and it has to be prepared for. It is a cost that all users have to bear. Thank you.
Thank you. And Allison.
I would echo some of the other panelists, Bob Rosner in particular. You know, I think it's clear from the testimony here in this symposium that it's really important to honestly discuss the risks of any technology and with the people who may be impacted by that technology. And as Bob pointed out, you know, trust is absolutely important. It's absolutely essential, and it can be lost in an instant. And that loss can be compounded by continued responses from the government and industry. And I think that's exactly what we've seen in the situation with Fukushima and Chernobyl and, you know, 3 Mile Island. So, and it can be difficult, I think. My observation would be it's difficult for the industry to have some of these conversations because they've been put on the defensive often. But really, this has to be discussed openly and honestly, and smaller events need to be responded to rapidly and transparently. I'll leave it there.
Great, thanks. So now I'd like to turn from the past maybe to something more forward-looking, how we can better prepare for the next nuclear disaster, wherever it may be, and how we can better prepare to have those conversations with potential victims. And I think the interesting thing about this situation is that we're all consumers of energy as well as potential victims, right? We're on both sides of this, all of us. So maybe, Edward, to start with you, what lessons from other disaster response efforts should possibly inform our approaches to bringing compensation issues into our preparedness schemes? And you've also talked a little bit about how to communicate with the public about these complexities in the past. So how would you bring that into your thinking here?
Well, let me start with the issue of communication, if I can. I think that we have to communicate specifically about recovery from accidents and not just about the technological complexities of energy production methods, nuclear or otherwise. I want to reinforce the very powerful statements that we heard, because it is essential that we listen to people in communities as these initiatives may unfold in the future. The premise of our research that began just 3 years into the ordeal at Fukushima, our premise was that if commercial nuclear technology can help mitigate climate change, perhaps better understanding of options for compensation and assistance for reactor accident victims could help us become more effective in accident recovery preparedness. And so my colleague Ken Lerner and I embarked on a project to try to identify some of those other mechanisms. Professor Mitchell referred to the Price-Anderson Act, which is the statute that applies an overall cap to the amount of money that can be recovered in the United States from extraordinary nuclear occurrences, as the term is called. And that cap right now is about $13.8 billion, as I understand it. It fluctuates, but it's about that much, which is far less than the amount of damage that was done in Fukushima. Now, our research identified several instances in the United States of actual accidents, because of course, as the professor pointed out, as Ms. Mitchell pointed out, Price-Anderson Act was not invoked at the 3 Mile Island accident because the amount of damage was not that as it was not an extraordinary nuclear occurrence. And the actual recoveries from actual accidents that we studied did teach us some lessons. For example, the Deepwater Horizon oil spill, which killed 11 people, injured 17, evolved into a claims process that allowed for fairly simple and fairly rapid turnaround claims to be filed. And the major settlements were completed in about 5 years. They came to somewhere greater than about $30 billion. They involved strict liability by not just the operator BP of the oil rig, but also partners and upstream responsible parties. I am sorry to say to Mr. Kono that the types of claims did not include the type of cleanup that that his initiative envisions. And so I just want to close by saying that the system has to recognize victims better than it has been up until now. And we do have models that allow us to be able to do that. Thank you.
Very interesting. Thank you. So now, Allison, turning to you, as we think towards the future, what role do you think that nuclear regulators can play in creating a more just compensation scheme? And in particular, you've been a participant in many transnational regulatory conversations. Is there a need for some new cross-border regulatory initiatives? What do you think?
It's an interesting idea. I think there is need for a more accepted internationalized compensation scheme, especially in the situations where there could be cross-border contamination. And, you know, I think Europeans recognize this certainly after Chernobyl, as many of them were impacted by Chernobyl. And, you know, seriously, the Scandinavian countries and the UK had serious impacts from Chernobyl. And so I think in some ways it should be a requirement. If you want nuclear power, you have to make sure that you can be part of a compensation scheme and you have a plan for compensation if there is an accident. But of course, there's no one organization or one policeman policing the show. So it's difficult to do, and it has to be done with diplomacy. You can try to work this from the angle of the supplier countries, but again, you're going to have a difficult time convincing the Russians and maybe the Chinese to play the same way. You know, the Russians are going around and they are going to countries with really honestly inadequate nuclear regulatory regimes and asking them whether they want nuclear power plants, and the countries are saying yes, and they're beginning to move forward with that. That's really problematic. How those countries would respond in a situation where there's an accident and cross-border contamination within their borders, I don't know. But this is a thorny issue, and it deserves a lot more attention.
Thank you. Now, Robert, you've talked about the fact that the manufacturers of nuclear power plants are almost always absolved of liability. Why is that the case in your view? And who should be accountable in your view legally for nuclear disasters?
certainly historically, the reason for the focus on the operators had to do with and legislation such as Price-Anderson had to do with protecting an industry that was in the 1950s, 60s, still in its infancy, and that in a market economy, the pricing of risks that even then were pretty clear, for the obvious reason that the energy program was always associated in people's minds with the weapons program. Let's face it. That pricing would basically not make it possible to start the industry going. Now, my sense is that I think it's fair to say that the nuclear industry today, worldwide, is a pretty mature industry, and so this kind of protection of the industry really isn't called for. We're living in a world, certainly in most of certainly the European economies, here in North America, in market economies where you price risks, and the burden of responsibility and liability falls on all the participants. So who are they? They're not just the operators, but also the designers, the manufacturers, and in particular also the consortia that actually do the actual construction of the plant on site. One question that some people raise is, well, isn't this? Yeah, in fact, I think I heard this from one of the folks in Fukushima, that all these difficulties can be traced to the fact that we're living in a market or capitalist society. And I actually don't agree. I think that the kinds of acts like Price-Anderson are actually anti-market. They prevent the market from pricing the risks. In fact, they're designed to prevent that. That's the first point. The second point is that I think what you're really seeing is something that's not about capitalism or markets, it's about plain greed. I think greed is there, and it is a human failing. And if you ask, why it was that TEPCO, for example, consistently ignored the requests by the at that time fairly powerless regulator to actually address a whole bunch of safety issues at Fukushima Daiichi, well, yeah, they didn't want to spend the money.
Interesting, thank you. And finally, Rachel, the report that we're issuing today calls for the incorporation of more citizen dialogue into policymaking, and I think we've seen a lot of consensus on this panel that that's an important next step. How do we do that? How do we facilitate a more inclusive conversation between ordinary citizens and the experts in industry and in government?
Thank you. I think the report actually lays that out, and when they lay out their three key findings for how we get to better citizen participation. I think that the real takeaway, though, is their recommendations are absolutely essential and right, because every energy source has these challenges. Which is we are moving into an increasingly hungry energy environment, not less, but more, as more globally become hungrier and hungrier, and rightfully so, for access to energy. And we see this call in the nuclear space for making sure we have citizen participation. But we see some of these same challenges with pipelines, right? Not in my backyard, windmills, not in my backyard, fracking, not in my backyard. And so there's a lot of no's that go around procurement of energy because it's dangerous and dirty, each in their own way. We saw it in the chat, somebody who put out a question about, you know, how many coal miner deaths do you have, or how many death by coal is saved through nuclear. And we don't want to be in a pain Olympics about this, but to recognize that each energy source has significant challenges and are dirty, and yet our economy and our lifestyle and citizens demand it. And so I think what we've seen, there's some lessons from around the world. I tend to kind of focus a bit on Manitoba Hydro, because they spent a lot of time having challenges moving hydroelectric through their populations, and then all to where they were distributing. And after a long period of time, came to the realization that only by citizen engagement, both in terms of understanding the risks, but also where there were benefits, understanding them and coming together in a dialogue, could they move forward with hydroelectric. And they were trying to share this lesson with the oil pipeline folks who were trying to move the Keystone pipeline, and which wasn't successful. And so what we learn in the few examples, Bob Rosner often talks about the Scandinavian countries, Finland in particular, who's been very successful in being able to bury nuclear waste because of the citizen participation. Usually that's a fight about not in my backyard, but Finland's found a way to bring their citizens into a conversation. So these findings of this report become very, very important, both in terms of compensation, but also in terms of being able to come together as communities to engage on what kind of risks they will take and what kind of protections will they need if they take on those risks, that I think are a key finding for moving forward as we move forward into this energy hungry future.
Thank you, very well said. Great, so we're gonna have to stop here. So what I'd like to do now is, first of all, thank you all very much for your comments, and now invite all of our speakers today to turn on your cameras and microphones and join us on stage for live Q&A. And while they're doing that, again, remind everyone that you can follow this Q&A in either English or Japanese. The translation information is in the chat. Okay, so there are many, many questions, which is great. I think the first question might be for Mr. Kono. So, Mr. Kono, there is one of our listeners was very moved by your observation that no amount of financial compensation can return your life to what it was before, and was very impressed and moved that your lawsuit is really not about money. But then this person asks, how do we create a compensation system for an environment in which money does not work as a form of compensation, that it's not sufficient? What would you propose for the future, for the next accident? What do we do if money can't make you whole?
Hi, ありがとうございます。今野です。最終的にはですね、私たちは現状回復を願っています。結城アシナ先生がおっしゃってましたけれども、その賠償でもって償えない部分というのは最終的にどうしても残るんですね。で、現在の制度では、それがいわゆる地域コミュニティの喪失、消滅、そういう部分についての賠償というのは、現在の制度では一切ありません。だからそれは、作ってしかるべきものではあるんでしょうけれども、しかし私たちが最終的に願うのは、その地域住民が協力し合って、その自然の中で、お互いに協力し合って、生活すると、そういう平穏な生活そのものの回復を願ってるんですね。少なくとも自然環境が放射能から解放される形で元に戻れば、それは可能なことですので、 なかなか技術的な制約もあって難しい面もあるんでしょうけれども、それが私たちの願いということです。ありがとうございます。
Thank you very much. And now a question for Mayor Yoshida and Mr. Suzuki. So actually, first for Mr. Suzuki, one of our viewers would like to know whether in Japan there is any stigma associated with being a refugee from Fukushima, whether any of the citizens in your community suffer from being associated with the accident, and also whether there's any stigma or pressure not to bring lawsuits, whether you have felt that people expect you to compromise rather than bring lawsuits or not.
まず被害を受けてですね、原発の被害者だっていうことで、各地に避難した際に、この放射能に汚染されたということで差別されたりですね、いじめにあったりとか、そういうことは実際に生活の多々ありました。私の家内などは別な市に避難しましてね、そこで病院に行った際に、原発被災者だから受診しない、あるいは検査をしないなどという差別をですね、実際受けています。つい最近の話です。あるいは原発訴訟そのものに対するですね、批判的な、あるいは国民として、国民の皆様から受け入れないような、そういう話は今のところはありませんね。以上です。
Thank you. And Mayor Yoshida, another question is about the time frame of accidents, of claims. And actually, maybe this is a question that Ms. Ashina also might have a view on. Are you concerned that there is a time limit to when you can bring claims, but that the accident, the damage, for example, to health might be experienced many years later, or maybe even in the next generation? So how do we handle the fact that the time of discovering accidents may be much longer than the statute of limitations of the law? Mayor Yoshida? So maybe I should direct the question first to Ms. Ashina. Ms. Ashina?
Okay, so thank you very much for asking. So now the statute of time limitation is extended as long as 10 years, but now this is ended. So we attorneys try to extend the statute of limitation again, but unfortunately, it is really difficult to try to extend the statute of limitation. So there are several reasons because the typical strongly resist to extend the limitation because they try to finish their compensation. But as we already discussed, there are so many suffering that's still ongoing. There is still possibility to cause their further harms in future. So we are anxious about to deal with the future harms probably happen in the residents.
Thank you. Professor Otsuka, I wonder if you have an opinion on this as a former judge and lead lawyer for the claimants.
はい、私は対馬訴訟の弁護団の共同代表をしています。今野さんがお話しされたように、多くの住民はもうお金じゃない、ここに戻りたいのだということを訴訟を起こす5年前からずっとおっしゃっています。 それは被災っていうものが奪っていったのはお金で買えないものだからです。人間にとって一番大事なものはお金で買うことができないものです。その中にはすべての社会的な共通資本、ソーシャルコモン、キャピタルが含まれています。そして人と人とのつながり、人と自然との密接なつながり、そういうものが奪われたとき、その地球の一部は廃墟と化してしまいます。そういう地球の一部を廃墟と化していくようなことを放置してよいのかが、この原発訴訟が問いかけているものです。汚したらきれいにするという原則を地球において確立しない限り、地球に未来はないと考えています。ですので、除染をしろという訴訟を私たちはやっています。
Thank you very much. Now, turning to a different aspect of this subject, we have a question about the situation in the United States. So actually several questions, and I'm going to put them together. Professor McFarland talked about the importance of natural disaster review. She talked about the importance of retrofitting aging reactors with new technologies to make them safer. The question, Allison, for you and for others is, do we think that all of these changes that you are proposing are actually likely or possible to happen in the United States? And the question from some of our colleagues in Japan put in different ways, why haven't we done this? So perhaps could you respond to that?
Sure, I'll start. So the US right now is not going to do these things. The Nuclear Regulatory Commission, the commission itself, has refused to do them. Other countries have chosen to do them, and Japan is doing both, and they have been doing for the last 10 years. Both they've been adding these filters to their vents, and they have been doing seismic reviews, which is in part why a number of the previously operating reactors have shut down, because they've been found to actually be located on active fault zones, for instance. So Japan has been taking these measures. The United States has not.
Interesting. Anyone else want to comment? There's another piece of this in the chat. Someone asks, do we expect any change in policy as a result of the Biden administration? Has there been any yet? Has there been any signal that there will be?
Policy around safety of nuclear
Yes.
energy? Or,
yes.
Not yet. We'll see. You know, again, going back to my last slide, really, ideally, a nuclear regulator and nuclear safety is not dependent on politics. It is divorced from politics, and it's just focused on the mission of ensuring that humans and the environment are kept safe in the operation of reactors. So it really shouldn't matter whether there's a Biden administration or a Trump administration. Unfortunately, that's not been the practice.
Thank you. Okay, we have a question about new forms of small nuclear reactors. So one of the commentators points out that there's been a lot of excitement around these as possibly a safer technology. How should we think about these in this context? How should we regulate them? Maybe on the technological side, let's see. Robert, do you want to take that? What do you think?
I can start, but I think there's a few other people who might have some opinions about this. But my sense is that there's really nothing special from the safety perspective about small modular reactors. It is true that the designs that, in particular, the one by NuScale here in the United States, is safer has substantially more safety margins than existing gigawatt-scale reactors. But there are gigawatt-scale reactor designs that are also safer than the existing generation 2 reactors. I think so the issue is there's nothing really special in the United States about SMRs except for the fact that they lower the initial capital costs. So if you like, they lower the risk, the economic risks to the utilities that order these reactors. And that is the principal reason they're actually of interest. The other issue, which is peculiar to the United States, and why the SMRs might be of interest here, is that our nuclear industry has not built a gigawatt-scale reactor in decades. And the consequence of that, we can see in what happened in Georgia and South Carolina. The cost overruns that were suffered by Westinghouse and its collaborating companies are just astonishing, but not surprising, given the fact that Westinghouse has not built a reactor in something of the order of 30 years. So they're basically missing the crafts, the folks, the plumbers, the concrete workers, all those that know how to work to the specifications needed for a nuclear power plant. This is not true elsewhere in the world. The South Koreans know how to do it. The Japanese know how to do it, but we don't know how to do it. And the hope with SMRs is that you can get around this problem by building these things in factories on a kind of an assembly line basis. Whether or not that actually will ever really happen, whether the order book will be there to climb up the learning curve that you need in order to actually build these things at an economically justifiable cost, well, that's still unknown. We don't know that.
Great. And what about, Mary, what about the liability and compensation schemes around these? Should there be any difference in your view?
So what I want to emphasize with these devices is that their features that make them desirable in some ways, their smallness and their modularity also change the topography of risk. So I'll use Canada as an example, where it's anticipated that these small modular reactors might be placed in communities that are difficult to reach by grids. They might be used in heavy industries such as mining, and they might just be plugged into regular grids as well. Well, this is potentially putting different kinds of communities, different groups of workers, different groups of people newly at risk from nuclear energy. So if we anticipate a world in which we have more reactors, they may be smaller and they're distributed more widely. I think that underlines the need to re-examine liability and compensation regimes and to involve the public who may be newly at risk in those discussions. Now, industry has called, in the Canadian example, has called, for instance, for some adjustments to liability regimes, chiefly for the lowering of the financial insurance that a reactor operator must carry. So there is some understanding that with changing technology, this is also going to interplay with liability. But my point would be that just as industry wants certainty, members of the public also want certainty and deserve certainty with how they will be taken care of if an accident were to occur.
Interesting, thank you. So now we have a very challenging question, and Edward, I'm going to put it first to you. In response to the conversation about really engaging the public about the risks and making sure that we have a real social contract around those risks, one viewer asks, can people ever consent to the potential dangers of experiencing the kinds of things that Mr. Kono and Mr. Suzuki described today? I mean, is it possible really to have, legally effective consent for that in advance? What do you think?
Those decisions are not individual decisions. They're community decisions. And so in well-functioning communities, there's dialogue because different people have different views and different set points for what they are prepared to accept. And so I think that it is best thought of in terms of how a given community decision is going to be made. And if on a community basis, there is not consent to what the community believes the risks are from its perspective, then one can hope that in a society in which self-determination is the decision-making method, by one means or another, that the outcome would be to not have whatever it is put there. But we certainly see often at the end of these debates on a community level that there are ways that are found to live with the risk. And I think the most important thing is that the decisions are based on honest and widespread understanding of what the social contract really is.
Well, thank you for that. I'd just like to give Mr. Suzuki and Mr. Kono an opportunity to respond. What kind of community conversation was there prior to Fukushima accident in your community about the risks? Was there a conversation? Did you agree in advance?
今野ですがよろしいでしょうか。原発のリスクに対する地域内での、なんていうのかな、今、そういう意味での対話というのは、ほとんどないに等しい状況でした。なぜかというと、国、もしくは東京電力の方からですね、いわゆる原発安全神話と一般的に言われている、なんていうのかな、多重防護をされているので、決して日本の原発は重大事故を起こさない、起こすはずがないということを繰り返しですね、宣伝しておりましたし、そういう趣旨の定期刊行物も地域内に配っておりました。私の場合、それを盲信していたわけではないんですが、一般的な意味合いで、そういうふうな共通認識が地域の中でも、それなりに共有されてたというか、したがって原発に関しての危機意識を前提にですね、地域内で、議論が行われているというような、そういうような状況にはなかったということですね。大いに反省しております。以上です。
鈴木ですが、今、今野さんのお話の通りです。で、その陰でですね、東京電力に対する安全操業の義務、および日本政府がですね、それを法的に指導する、そういう権限がありながらもですね、全くしなかったと。いわゆるそれが今回の事故の原因になったと。そういう国と東電のやり取りも我々の国民の前には全く分かりませんでしたね。あったのは、いわゆる安全神話、それだけだったと思います。で、それに我々も、その神話に、洗脳されていたというのが実態ですね。以上です。
Very interesting. Thank you very much. So final question, and I want to make this available to anyone and everyone. The question raises, who pays for all of this compensation? Concretely in Japan, who pays, when there's a settlement? And who should pay in this situation? And of course, I know that, of course, Sonia can speak about how it works in a socialist and post-socialist context. We can think about how it works in the United States. Who should ultimately pay the cost of compensating victims? Anyone? Maybe we could start with the Japanese, just the facts on Japan. Can somebody respond to
In
that?
Japan, yeah,
Yeah.
in Japan, now the TEPCO is has only responsibility to pay their compensation, but in the fact, the fund is stemmed from the Japanese government, so we Japanese, the taxpayer, contribute to pay their compensation. This is Japanese present scheme.
Thank you. Thoughts from anyone on who pays or who should pay?
Well, I can
Yeah.
say that, oh, excuse me.
Go ahead, Edward, that's
Thank
fine.
you. My apologies. I think I can say that in the United States, it is not clear who would pay because the situation hasn't presented itself, and the operation of the law is uncertain in this area because some of the costs could be imposed on the utility or could become government costs. And just at that very basic level, it's unclear how that would be handled.
Robert?
Yeah, maybe I can just add that actually there have been accidents which in terms of scale here in the United States that mirror what happened in Fukushima Daiichi, and the blowout in the Gulf in BP's well is an example of that.
Mm-hmm.
And if you ask who paid, well, yeah, BP paid, but BP by far didn't pay everything.
Mm-hmm.
The end result was that U.S. government ended up paying. And I think just the fact of the matter is, in accidents of that scale, even the largest corporations of the world, like BP, are actually incapable of actually funding the damage needs. So ultimately, let's face it, it's going to be a government responsibility.
Mr. Suzuki, I'd like to give you the last word, please.
はい。私ども浪江原発訴訟では、被告は国と東京電力です。したがって賠償金を払う責任があるのは国と東京電力であると。現在、日本では30数件の裁判が行われています。最近は仙台高等裁判所、それから東京高等裁判所でもですね、国に責任があると。東電と同等の責任を持って賠償をしなければならない。そういう判決も出ています。今、大方、国にその責任を求める方向に流れております。以上です。
Wonderful. Well, this has been a wonderful conversation, and I really want to thank all of you for participating and for your time. And now I just turn it back over to Hiro to close this out.
Well, once again, thank you for joining us today, and special thanks to all of the panelists and speakers, and as well as Northwestern Buffett and the Bulletin of the Atomic Scientists for co-sponsoring this event. We had a very productive conversation. And for those who have not had a chance to read the report, we have included a direct link in the chat below. So once again, thank you all for joining us today, and let's continue our conversation. Bye.